Next page. Indirect application of the Bill of Rights. A. General principles. Indirect application. Constitution and Bill of Rights do not directly bind actors but influence through statutory or common law. Legal disputes should first be resolved using existing law, interpreted or developed in line with Bill of Rights values before applying the Bill of Rights directly. Statutory law. Courts must first interpret legislation to conform with the Bill of Rights. Indirect application. Before declaring it invalid due to conflict. Direct application. Common law. Courts develop common law in line with the Bill of Rights rather than assessing its conflict directly. B. Indirect application to legislation. Duty to interpret in conformity with the Bill of Rights. I. Scope of the duty. Bill of Rights binds original and delegated lawmaking authorities and can be directly applied to legislation. Courts must first attempt indirect application by interpreting legislation to align with the Bill of Rights before resorting to direct application and invalidation. Section 39(2) imposes a general duty on courts, tribunals, and forums to promote the Bill of Rights spirit, purport, and objectives in statutory interpretation. The legislature is presumed to intend alignment with the Bill of Rights unless proven otherwise. The duty applies even if the litigant does not cite Section 39(2). Courts must consider the Constitution's normative framework in all cases involving common law development. If legislative provisions could be interpreted in ways that either violate or comply with the Bill of Rights, courts must choose the latter. Under the interim Constitution, this interpretative approach was known as reading down. Section 35(2). The 1996 Constitution does not explicitly restate Section 35(2), but Section 39(2) requires courts to continue applying the reading down approach. When multiple interpretations of legislation are possible, courts must choose the one that best promotes the spirit, purport, and objectives of the Bill of Rights, even if none are unconstitutional. Next page. 2. Methodology for indirect application of the Bill of Rights. Govender v. Minister of Safety and Security, Standard Formula for Constitutional Challenges to Legislation. The Supreme Court of Appeal outlined a structured approach for adjudicating constitutional challenges to legislation. 1. Examine the purpose of the act or section under review. 2. Assess the scope and meaning of the constitutional rights involved. 3. Determine whether a constitutional interpretation of the act or section is reasonably possible. 4. If possible, apply the constitutional interpretation. 5. If not, initiate steps for a declaration of constitutional invalidity. Limitations on interpretation power. The power to interpret legislation in line with the Constitution is not unlimited, it must be reasonably possible to do so. Courts should not distort statutory meaning to fit the Bill of Rights, as this would undermine their power to declare laws invalid and restrict the legislature's constitutional role. Hyundai Motor Distributors case. The Constitutional Court held that an interpretation should not be unduly strained. A constitutional interpretation must be plausible, it must be defensible using established legal principles of statutory interpretation. Purposive and contextual interpretation. Courts must interpret legislation purposively and contextually to achieve compliance with the Bill of Rights. If the only plausible interpretation of a provision results in a Bill of Rights infringement, the court must assess whether the infringement is justifiable. If unjustifiable, the provision must be declared unconstitutional. Interpretation in conformity is not always restrictive. The term reading down can be misleading, as it suggests that courts always restrict statutory provisions to avoid rights violations. Narrow interpretation may be required in cases where discretionary powers are too broad, regulation is over-inclusive, criminal law changes have excessive impact. Expansive interpretation may be required where the lack of discretionary power in a statute causes constitutional invalidity. Courts must resolve ambiguity by adopting the interpretation that best conforms to the Bill of Rights. Section 39(2) applies only to statutory interpretation, it does not affect the interpretation of the Constitution or the Bill of Rights themselves. Next page. 3.4 Indirect application of the Bill of Rights. A. General principles. Definition. Indirect application means that the Constitution and Bill of Rights do not directly bind actors, instead, their influence is mediated through statutory or common law. Principle. Legal disputes should first be resolved using existing principles of ordinary law, interpreted or developed in line with Bill of Rights values, before resorting to direct application. Statutory law. Courts must first attempt to interpret legislation in conformity with the Bill of Rights. Indirect application. Before considering its invalidity, Direct application. Common law. Courts should develop the common law to align with the Bill of Rights before evaluating whether it conflicts with it. B. Indirect application to legislation. The duty to interpret in conformity with the Bill of Rights. I. Scope of the duty. General rule. The Bill of Rights binds all lawmaking authorities, meaning it can always be applied directly to legislation. Court obligation. Courts must attempt indirect application first, interpreting laws in conformity with the Bill of Rights before considering invalidation. Section 39(2) mandates courts, tribunals, and forums to promote the spirit, purport, and objects of the Bill of Rights when interpreting legislation. Legislative intent presumption. Laws are presumed to align with the values of the Bill of Rights unless proven otherwise. Duty applies regardless of reliance on S39(2). Even if a litigant does not invoke S39(2), courts must still interpret statutes in line with constitutional principles. Incremental common law development. Courts must always consider the normative framework of the Constitution when interpreting legal provisions. Avoiding conflict with the Bill of Rights. Reading down. Introduced under the interim constitution's S35(2), requiring courts to choose a narrower interpretation of legislation to avoid constitutional violations. 1996 Constitution. Though S35(2) is absent, the duty to read down remains under S39(2). Preference for Bill of Rights-friendly interpretation. If a provision has two possible interpretations, the one that better promotes the Bill of Rights objectives must be adopted, even if neither would render the law unconstitutional. 2. Methodology for constitutional interpretation. Govender v. Minister of Safety and Security, Standard Formula. Courts must 1. Examine the purpose of the act or provision. 2. Define the scope of protected rights in the Constitution. 3. Determine if a constitutional interpretation is possible. 4. Apply that interpretation if it aligns with the Constitution. 5. If impossible, consider invalidation of the provision. Limits on interpretation powers. Judicial restraint. Courts cannot distort statutory meaning to fit the Bill of Rights. This would render invalidation powers superfluous and undermine the legislature's role. Reasonably possible standard, SCA. Interpretation must be plausible, not an exercise of judicial overreach. Hyundai Motor Distributors case. The Constitutional Court ruled that an interpretation should not be unduly strained. Courts must rely on legitimate interpretive aids from statutory law. Purposive and contextual interpretation. Legislation must be interpreted in a purposive and contextual manner. If the only plausible interpretation results in a Bill of Rights infringement, the court must assess whether it is justifiable. If not justifiable, the provision must be declared unconstitutional. Expanding versus restricting interpretation to conform with the Bill of Rights. Reading down is not always restrictive. Courts may need to interpret laws more broadly in some cases. Narrow interpretations may be necessary when discretionary powers are too broad. Over-inclusive regulations exist. Criminal law changes have excessive impact. Expansive interpretations may be required when a lack of discretionary power causes constitutional issues. Ambiguous laws must be interpreted in a manner that best conforms to the Bill of Rights. Section 39(2) applies only to statutory interpretation. It does not affect how the Constitution or the Bill of Rights are interpreted. Next page. Indirect application of the Bill of Rights to disputes governed by the common law. The obligation to develop the common law. Legislation is first interpreted with the Constitution in mind before direct application. Common law follows a similar approach, but the courts, not the legislature, have the power to develop it. Courts have inherent power to modify common law to align with evolving societal values. This power is now constitutionally mandated and must align with constitutional values. Instances requiring development of the common law. 1. When a common law rule conflicts with a constitutional provision, the rule must be adapted. 2. When a rule is not inconsistent with a constitutional provision but does not fully align with its spirit, purport, and objectives, it must be developed to harmonize with constitutional values. Threshold analysis for constitutional challenges. The court first determines whether a common law rule limits a constitutional right. If the limitation is unjustifiable, the court must develop the rule to align with constitutional norms. Carmichael case, constitutional obligation to develop the common law. The Constitutional Court ruled that courts have a general obligation to develop the common law. The obligation applies even if parties do not request it and in both civil and criminal cases. 2. Methodology of indirect application to the common law. 1. Reforming existing common law principles. Courts can modify principles to better align with the Bill of Rights. Examples. Defamation law has been adapted to balance free speech and dignity. Restraint of trade, attempts to reform the onus based on S-22, right to occupational freedom, have been less successful. Contract law, courts have been more resistant to reform compared to delict. 2. Applying common law with due regard to the Bill of Rights. Courts interpret common law in light of constitutional values. Example, Rivet Carnac v. Wiggins. The court considered constitutional commitments when deciding that certain professional criticisms were not defamatory. 3. Giving constitutionally informed content to open-ended concepts. Open-ended concepts like public policy, contra bonos mores, and unlawfulness must be interpreted through a constitutional lens. Example, Barcason v. Napier. A contractual time bar clause was challenged under S-34, right of access to courts. The court applied a constitutionalized version of public policy. The Maloney test was used. Time bar clauses must not be unreasonably short or inflexible. Example, Bread Income v. Standard Bank. Issue, whether banks have a contractual duty to act fairly when closing accounts. The court ruled that fairness is not a self-standing requirement in contract law but must be assessed in the matrix of constitutional values. Autonomy in contract law remains a key principle. 3. Limits on indirect application to the common law. 1. Incremental development. Courts must develop common law case by case, not in the abstract. Example, Shabalala v. Attorney General, Transvaal. The Constitutional Court struck down a common law rule but balanced guidance with flexibility for future development. 2. Stare decisis, precedent and binding authority. Courts have more flexibility in developing common law than in interpreting statutes. Development must respect the doctrine of precedent. 4. Stare decisis and indirect application. 1. The Govender and Walters cases. Govender v. Minister of Safety and Security. High Court read down S-49 1B of the Criminal Procedure Act to avoid unconstitutionality. S. v. Walters. The Transkei High Court refused to follow the Supreme Court of Appeal, SCA, decision in Govender. Ruled that appeal court decisions on constitutional issues are not binding unless confirmed by the Constitutional Court. The Constitutional Court rejected this approach. High courts must follow the SCA's constitutional interpretations unless overturned by the SCA or Constitutional Court. 2. The Afrux decision and its three categories. Afrux Healthcare BPK v. Stridham clarified when high courts can depart from pre-constitutional precedent. 1. Direct application of the Constitution to the common law. If a high court finds that a common law rule directly conflicts with the Constitution, pre-constitutional precedent is not binding. 2. Pre-constitutional decisions based on open-ended standards. If a precedent relies on boni mores, public morality, or public interest, a high court can depart if those values have evolved. 3. Indirect application under Section 39(2). Pre-constitutional precedent remains binding even if a rule needs to be developed to align with constitutional values. 3. Key takeaways from Walters and Afrux. Post-constitutional decisions of higher courts are binding on constitutional and non-constitutional issues. Pre-constitutional decisions of higher courts remain binding, except in cases of direct constitutional conflict. Open-ended moral/public interest considerations. Section 39(2) does not allow lower courts to ignore binding precedent. 4. Criticism of Afrux and Walters. Afrux overlooks statutory interpretation under S-39(2). Post-Afrux, high courts may still depart from pre-constitutional statutory interpretations. Kumalo v. Halamisa suggests direct horizontal application could be a way to bypass restrictive precedent. Next page. Study notes, application of the Bill of Rights in legal disputes. 3.5 The manner of application of the Bill of Rights. A. Currency of the distinction between direct and indirect application. Under the 1996 Constitution, there is a single legal system. The Constitution applies to all law, informing its interpretation, development, and validity. The previous division into constitutional and non-constitutional law under the interim constitution is no longer valid. The distinction between direct and indirect application remains practically relevant, especially concerning the common law. B. Jurisdiction. Under the interim constitution, Direct application of the Bill of Rights was a constitutional matter under constitutional court jurisdiction. Indirect application was not a constitutional matter and fell under the jurisdiction of the Appellate Division. In Duplessis v. de Klerk, the Constitutional Court held that indirect application of the Bill of Rights was not a constitutional matter. Under the 1996 Constitution, all superior courts have both direct and indirect application powers. Jurisdictional concerns remain significant for legislation, as High Court and SCA decisions on legislative validity require constitutional court confirmation. C. Purpose and effective direct versus indirect application. Direct application determines if a law is inconsistent with the Bill of Rights. If so, the law is declared invalid. This limits legislative options in amending or replacing the law. Results in a constitutional remedy. Indirect application avoids inconsistency by interpreting or developing law in line with the Bill of Rights. Does not generate a constitutional remedy. Key judicial approach. Courts avoid broad constitutional pronouncements. Prefer narrow, case-specific rulings to preserve legislative discretion. Little practical difference in common law cases as both methods lead to constitutional conformity. Key exception: when common law does not provide a cause of action, direct application is necessary. D. Indirect application must be considered before direct application. Principle of avoidance: courts should resolve cases without deciding constitutional issues unless necessary. S. v. Mlung. General principle: avoid constitutional rulings unless necessary. Zanzi v. Council of State, Siskay. Courts should not anticipate constitutional questions before necessity arises. Allows for incremental development of law. Justifications for avoidance. 1. Procedural. Under the interim constitution, referrals to the Constitutional Court were required for constitutional issues. The 1996 Constitution replaced this with wider High Court jurisdiction and an appeal-based system. 2. Substantive. Avoids restricting legislative authority by preempting necessary legal reforms. Courts should allow legislature and executive to interpret and apply the Constitution before ruling. The Constitutional Court avoids ruling on statutes until trial and appeal courts assess their impact. 3. Practical. Encourages incremental jurisprudential development. Courts decide only on essential issues based on the facts of a case. Impact of avoidance. The Bill of Rights applies in all disputes. Direct application is available but should be used only when necessary. Indirect application should be considered first in all cases. These principles shape how courts apply the Bill of Rights, balancing judicial intervention with respect for legislative processes. Next page. Additional study notes. Direct application of the Bill of Rights. 1. Ordinary law must be applied first. Even when the Bill of Rights applies directly, courts must first apply ordinary law if it is designed to give effect to constitutional rights. Statutes such as the Labor Relations Act 66 of 1995, Equality Act, and Administrative Justice Act are meant to implement the Bill of Rights. These statutes must be applied first and, if necessary, interpreted generously to align with constitutional principles before considering direct application. The same applies to common law. It must first be applied and, if needed, developed in line with the Bill of Rights before direct application. 2. Challenging conduct before challenging law. When the Bill of Rights is applied directly in cases involving legislation, the conduct implementing the law must be challenged before the law itself. This prioritization avoids unnecessary constitutional challenges unless the provisions of the statute are directly at issue. 3. Exceptions to the avoidance principle. The principle of avoiding constitutional issues is not absolute. It does not mean litigants can invoke the Constitution only as a last resort. Direct constitutional application is justified when the constitutional violation is clear and directly relevant. No alternative remedy is available under ordinary law. Avoidance remains important when the applicant's interest in resolving the constitutional issue is unclear. The issue is not ripe for decision or has become moot. Next. Chapter 4 Justiciability 4.1 Limitations on Justiciability 4.2 Standing. A. Introduction, a broad approach. B. The implications of the doctrine of objective constitutional invalidity. C. The allegation that a fundamental right has been infringed or threatened. D. Sufficient interest in the categories of persons. I. Persons acting in their own interest. 2. Persons acting on behalf of another person. I. Persons acting as a member of a group or class of persons. 4. Persons acting in the public interest. V. Associations acting in the interest of their members. 4.3 Ripeness 4.4 Mootness. A. General principles. B. Exceptions to the mootness doctrine in the interests of justice. Page. Study Notes, Chapter 4, Justiciability. 4.1 Limitations on justiciability. Justiciability refers to whether a court can hear and decide a legal dispute. Certain limitations exist, including political questions that should be resolved by other branches of government, lack of jurisdiction in certain matters, doctrines such as ripeness and mootness that prevent courts from ruling on hypothetical or irrelevant issues. 4.2 Standing. A. Introduction, a broad approach. South African courts take a broad approach to standing, allowing individuals and groups to bring cases where constitutional rights are affected. The approach is informed by the principle of objective constitutional invalidity, which means unconstitutional laws or conduct must be struck down regardless of who challenges them. B. Implications of the doctrine of objective constitutional invalidity. Once a law or conduct is found unconstitutional, it is invalid for all, not just for the litigant. Standing rules are therefore broader to ensure unconstitutional provisions are properly challenged and removed. C. The allegation that a fundamental right has been infringed or threatened. To establish standing, a litigant must show that a constitutional right has been violated or is under threat. The courts consider whether the alleged violation has actual or potential impact on the litigant or society. D. Sufficient interest in the categories of persons. I. Persons acting in their own interest. Individuals can bring a case if their own constitutional rights are affected. 2. Persons acting on behalf of another person. Allows litigation where the affected person cannot act on their own behalf, for example, minors, detained individuals. 3. Persons acting as a member of a group or class of persons. A person may litigate if they belong to a group or class whose rights are collectively affected. 4. Persons acting in the public interest. Allows challenges where the broader public is affected, even if the litigant is not personally harmed. V. Associations acting in the interest of their members. Groups or organizations may bring cases on behalf of their members, provided they demonstrate a direct link to the issue. 4.3 Ripeness. A case must be ripe for adjudication, meaning that the issue is fully developed and not based on hypothetical or premature concerns. Courts avoid ruling on matters that are speculative or where there is no immediate and real dispute. 4.4 Mootness. A. General principles. A case is moot when the issue is no longer relevant or when resolving it would have no practical effect. Courts generally decline to hear moot cases unless there are compelling reasons. B. Exceptions to the mootness doctrine in the interests of justice. Courts may still hear a moot case if it raises an important constitutional issue. There is a public interest in resolving the matter. The issue is likely to recur and evade future review. Next. Page. Study Notes, Standing and Objective Constitutional Invalidity. 4.2b The implications of the doctrine of objective constitutional invalidity. Ferreira v. Levin. No, the Constitutional Court examined whether an examinee in a liquidation inquiry could challenge a provision in the Companies Act based on fair trial rights for accused persons. Ackerman J's interpretation. Section 7(4)(a) of the Interim Constitution, now S38 of the 1996 Constitution, imposed a qualification on standing. A person acting in their own interest must show a fundamental right of their own was infringed or threatened. A person acting on behalf of another must allege that the other person's fundamental right was under threat. Since the examinees were not accused persons, they could not invoke accused persons' fair trial rights but could rely on their right to freedom. Majority judgment, Chaskalson p. Rejected Ackerman J's narrow approach, favoring broader standing in constitutional cases. The applicant's challenge was not hypothetical. They had a sufficient interest because the Companies Act provision affected their common law rights and carried possible criminal consequences. Test for standing. 1. An allegation that a right in the Bill of Rights has been infringed or threatened. 2. A sufficient interest, linked to one of the categories in S38A, E, but not necessarily their own interest. Key consequence of Ferreira. Applicants do not need to allege a specific person's right was infringed, only that, objectively, a right in the Bill of Rights was infringed or threatened. However, the sufficient interest requirement still applies. Underscore. 4.2c The allegation that a fundamental right has been infringed or threatened. Threshold requirement. The applicant must allege that a right in the Bill of Rights has been infringed or is under threat. The term threatened allows applicants to seek an interdict to prevent future violations. Example, a person fearing unlawful detention or search may seek an interdict before the violation occurs. Standard of proof at standing stage. The applicant only needs to allege a rights violation, not prove it at this stage. The court assumes the allegations are true when assessing standing. If standing is challenged in limine, the court must accept the applicant's stated basis for standing. Objective nature of rights challenges. The applicant does not have to prove their own rights were violated, only that a right in the Bill of Rights was infringed or threatened. Example. A male doctor charged with performing an illegal abortion can challenge the law based on a pregnant woman's rights, for example, freedom, security, privacy, equality. The doctor does not have to claim a personal violation of his rights, just that the law violates fundamental rights. Juristic persons and standing. Juristic persons, for example, companies, do not need to prove they are direct beneficiaries of a right under S84. Like individuals, they only need to allege a rights violation and show a sufficient interest in the remedy sought. Next page. Study notes, sufficient interest and categories of persons under Section 38. 4.2d Sufficient interest and categories of persons. No fixed test for sufficient interest. The applicant, or those they act for, must be directly affected by the law or conduct. The concept of sufficient interest is tied to the category of persons under S38. Application to different categories. Associations acting for members, S38T, must show members have a sufficient interest. Public interest litigants, S38D, must show the public has a sufficient interest, different from personal interest. Own interest litigants, S38A, must show the law directly affects their rights or interests. Interest must relate to the remedy sought. In Pryor v. Battle, the applicant had a sufficient interest in challenging marital power in civil marriages, as she was married under civil law. Did not have standing to challenge marital power in customary marriages under own interest. Also failed under public interest due to insufficient evidence. Multiple categories. Applicants may rely on more than one category of S38 to establish standing. In Pryor v. Battle, different arguments were made under own interest and public interest. I. Persons acting in their own interest. Own interest litigants are not a floodgate concern, so their sufficient interest is broadly interpreted. Must show the law directly affects their rights, interests, or potential interests. The interest must be real, not hypothetical or academic. Hypothetical, claimed but not real or true. Academic, not related to a practical issue. Standing may still be denied even if it results in an unlawful decision remaining in force. Case, Janse van Rensburg v. Minister van Handel en Nieuwerheid. Applicants were under investigation under the Harmful Business Practices Act. They were entitled to challenge all provisions likely to apply to them. Courts rejected the idea of waiting for individual provisions to apply before challenging them. No need to exhaust internal remedies if they do not provide alternative relief. 2. Persons acting on behalf of another. This category applies where a person cannot act for themselves, for example, detained individuals. Requirements. 1. The represented person must consent, or it must be clear they would have consented. 2. The represented person must have a sufficient interest in the remedy sought. 3. Class actions, persons acting as a member of a group/class, definition of a class action. One or more individuals sue on behalf of a larger group affected by a similar issue. Class members benefit from and are bound by the outcome unless they opt out. Key case: Sousa v. Permanent Secretary, Department of Welfare, Eastern Cape. Welfare recipients' grants were suspended without notice. The applicants sought relief for themselves and all affected grant recipients. The court approved the class action, setting requirements. Numerous class members, making joinder impractical. Common legal/factual issues among class members. Applicants' claims typical of the class. Fair and adequate representation by the applicant's legal team. High court orders. Class definition. Covered all recipients with grants suspended in the province. Disclosure order, government had to provide names of affected individuals. Publication order, information about the case had to be publicly disseminated. SCA decision. Class definition was clear and valid. Extended the doctrine of continentia causae, jurisdiction over entire cause for justice. 4. Persons acting in the public interest. 2 requirements. 1. Applicant must show they are acting in the public interest. 2. must show the public has a sufficient interest in the remedy. Public interest standing differs from class actions, S38C, as it is broader. Ferreira v. Levin No. Oregon J's factors for public interest standing. Alternative avenues. Is there another reasonable and effective way to bring the case? Nature of relief. Does it have general and prospective application? Affected groups. Who is directly or indirectly affected? Participation. Have affected groups had a chance to present arguments? Additional factors. Lawyers for Human Rights v. Minister of Home Affairs. Vulnerability of affected people. Nature of the right violated. Consequences of the violation. Timing considerations. If legislature is already addressing the issue, courts avoid prejudging it. The applicant must present enough evidence. Courts will hesitate without full information. Key case, Albute. NGOs challenged the president's use of pardon powers, claiming a violation of the rule of law. The NGOs had a sufficient interest in ensuring constitutional compliance. V. Associations acting in the interest of members. Requirements. Members must have a sufficient interest in the remedy. Not required to comply with common law rules, for example, proving constitution allows litigation. No need to prove the association has separate legal identity or property rights. Next page. Standing in constitutional litigation, Section 38D, sufficient interest in categories of persons. No specific test for sufficient interest has been established. Direct effect, the applicant, or the party they rely on, must be directly affected by the law or conduct challenged. Linked to Section 38 categories. Associations, S38T, must show members have a sufficient interest in the remedy sought. Public interest litigants, S38D, must show the public has a sufficient interest. Sufficient public interest differs from sufficient personal interest. Interest in relief sought is key. In Pryor v. Battle, the applicant had sufficient interest to challenge marital power in civil marriages but not in customary marriages due to lack of direct impact. Public interest claims must be backed by sufficient evidence for the court to adjudicate properly. Multiple categories can support standing. Applicants may rely on different categories for different challenges. Persons acting in their own interest. Easiest category for courts to accept. Must show direct impact on their rights or interests. Interpretation must be broad and generous, but interest must be real, not hypothetical or academic. Courts may deny standing even if it leaves an unlawful decision unchallenged. In Jonse van Rensburg v. Minister van Handel en Nieuwerheid. Applicants could challenge all provisions likely to be applied to them. No need to wait for individual applications of the law before contesting them. Exhausting internal remedies was unnecessary as no alternative relief was available. 2. Persons acting on behalf of another. Permitted when the represented party cannot act in their own name, for example, detained persons. Conditions. Consent from the represented party, if possible. If consent is not possible, circumstances must indicate they would have consented. Represented party must have sufficient interest in the remedy sought. 3. Persons acting as members of a class. Enables class action litigation. One or more persons sue on behalf of a group with a common claim. Class members are bound by the outcome unless they opt out. Key requirements. Class must be large enough that individual litigation is impractical. Common legal/factual issues must exist. Representatives must fairly and adequately protect the class interests. Sousa v. Permanent Secretary, Department of Welfare, Eastern Cape. Challenged mass suspension of welfare grants without notice. Court allowed class action due to large number of affected persons. Claimant's economic vulnerability. Government had records identifying affected individuals. Orders granted. Class definition order, defined affected individuals. Disclosure order, forced government to share records. Publication order, ensured affected individuals were informed. SCA upheld standing, noting class action was ideal for cases involving numerous vulnerable claimants. 4. Persons acting in the public interest. 2 elements. 1. The litigant must genuinely act in the public interest. 2. The public must have a sufficient interest in the remedy sought. Ferreira, Oregon J., set relevant factors. Whether there are other reasonable and effective ways to bring the challenge. The general and prospective impact of the relief sought. The number of affected persons and their opportunity to present evidence. Lawyers for Human Rights v. Minister of Home Affairs added. The vulnerability of affected people. The nature of the right being infringed. The consequences of the infringement. Challenges. Timing. If the legislature is handling an issue, courts may avoid interference. Evidence. Courts need enough evidence to make an informed decision. Albute, NGOs were granted standing to challenge the president's pardon power based on rule of law concerns. V. Associations acting in the interest of their members must show members have a sufficient interest in the remedy sought. Unlike common law requirements, no need to prove. Association's constitution allows it to sue. Continued existence or separate legal identity. Capacity to own property or incur obligations. Next. Page 4. Persons acting in the public interest. Most difficult category under S38D requires proof of 1. Genuine public interest on the part of the litigant. 2. Sufficient public interest in the remedy sought. Public interest standing extends beyond class actions under S38C. Factors for public interest standing: Ferreira and Lawyers for Human Rights, whether another reasonable and effective way exists to bring the challenge. The nature of the relief sought, general/prospective impact. The range of affected persons/groups and their opportunity to present arguments. Additional factors, from Lawyers for Human Rights. Degree of vulnerability of affected persons. Nature of the right being infringed. Consequences of the rights violation. Sufficient public interest in the remedy. Timing matters. Courts avoid interfering if the legislature is actively addressing the issue. Evidence required. Courts need a complete picture before allowing a public interest claim. Case law on public interest standing. Albute. NGOs challenged the president's pardon power on rule of law grounds. Court held that NGOs had sufficient standing due to their concern for victims of political violence and interest in ensuring constitutional compliance. Underscore. V. Associations acting in the interest of their members must prove members have a sufficient interest in the remedy sought. No need to meet common law standing requirements. Association's constitution does not need to authorize litigation. No requirement for continued existence, separate identity, or capacity to own property/incur obligations. Next. Page 4.3. Ripeness. Definition and rationale. Prevents courts from deciding hypothetical or abstract disputes. Ensures judicial power is used only for real or imminent harm to a right. Ripeness in South African law. Ackerman J. Ripeness is a justiciability doctrine tied to constitutional avoidance. If a case can be resolved without addressing constitutional issues, that approach should be taken first. Timing considerations. Courts assess 1. Fitness of the constitutional issue for decision. 2. Hardship of delaying adjudication. If a case can be dealt with more effectively later and an early ruling provides no advantage, the court may defer judgment. Exhaustion of ordinary remedies. Applicants must first seek ordinary legal relief before invoking constitutional rights. This includes reading down a statute before challenging it constitutionally. Exceptions. If ordinary remedies are unlikely to succeed, if the applicant would suffer serious and irreparable harm. Challenging statutes and regulations. A statute or regulation may be challenged before a public body completes its decision if there is a real threat of prejudice. An enabling provision in a statute may be challenged before subordinate legislation is enacted if it sanctions a rights violation. Overlap between ripeness and standing. If a case is not ripe, the applicant may lack sufficient interest to seek a remedy. SVA, the constitutionality of sodomy laws was raised, but the court refused to rule since the facts were unclear, calling it a theoretical and academic exercise. However, a person liable for prosecution generally has standing to challenge an offense before being prosecuted. Judicial intervention in the legislative process. Courts prefer to wait until a law is enacted before intervening. Exception: immediate intervention is justified if constitutional violations would occur before the law's enactment. No substantial relief would be possible after the legislative process is complete. Next. Page 4.4. Mootness. A. General principles. Definition: a case is moot when it no longer presents a live controversy, preventing courts from issuing advisory opinions on abstract legal questions. Ripeness versus mootness. Ripeness prevents premature adjudication. Mootness prevents courts from deciding matters too late when they no longer affect the parties. Key case law. J.T. Publishing v. Minister of Safety and Security. Court refused to declare provisions of the Publications Act 42 of 1974 unconstitutional because it had been repealed and replaced by the Films and Publications Act 65 of 1996. A declaratory order should not be given for moribund and futureless laws. President of the Ordinary Court Marshall Novi Freedom of Expression Institute. The Constitutional Court declined to confirm invalidity orders because the challenged law was about to be repealed. Even under the special appeal procedure, S-172-2D of the Constitution, the court followed an approach similar to S-21A of the Supreme Court Act 59 of 1959, dismissing the appeal as any order would have no practical effect. B. Exceptions to the mootness doctrine in the interests of justice. Judicial discretion. A case may be heard even if moot if it serves the interests of justice. Independent Electoral Commission v. Langburg Municipality. Mootness is not an absolute bar to justiciability. Courts exercise discretion based on interests of justice. Factors considered. 1. Whether an order would have practical effect for the parties or others. 2. The importance and complexity of the issue. 3. The extent of legal argument presented. Public interest cases. In class actions or public interest litigation, issues are less likely to be considered moot since a ruling may still have practical effects on others. The constitutionality of a statute should still be decided if it affects a broad group of people. Examples of exceptions. Case on non-statutory regulatory authority. The court ruled on rulemaking powers despite the repeal of rules because of conflicting judgments on the authority's powers. The issue affected government operations and constitutional rights vis-à-vis government employees' pension fund. A legislative amendment resolved the dispute, but the court still considered costs because they were linked to a constitutional issue. Next page. Chapter 5, Jurisdiction in Bill of Rights Litigation. 5.1 The relationship between constitutional jurisdiction and remedies. Constitutional jurisdiction determines which courts have the power to decide Bill of Rights disputes. The scope of jurisdiction impacts the remedies available to litigants. Courts must operate within their constitutional mandate when granting relief. 5.2 Structure of the judicial system. A. The interim constitution established a three-tier court system with the Constitutional Court at the apex. The Constitutional Court had exclusive jurisdiction over constitutional matters. The Supreme Court and High Courts retained jurisdiction over non-constitutional matters. B. The 1996 Constitution. I. A new hierarchy of courts. The 1996 Constitution restructured the judiciary, expanding the jurisdiction of all courts. The Constitutional Court became the highest authority on constitutional matters. The Supreme Court of Appeal, SCA, and High Courts could decide constitutional issues. C. Rationalization of the Superior Court structure. Efforts were made to unify the judicial system post-apartheid. The Superior Courts Act 10 of 2013 further streamlined court jurisdiction. 5.3 Jurisdiction in constitutional litigation. A. Jurisdiction of the Constitutional Court, S-167 of the Constitution. Final authority on constitutional matters. Decides issues of constitutional interpretation, validity of laws, and state conduct. Exclusive jurisdiction over specific constitutional disputes. B. Proposed amendments to the Constitutional Court's jurisdiction. The Constitution's 17th Amendment Act expanded the jurisdiction of the Constitutional Court to include any matter of general public importance. C. Criteria governing the Constitutional Court's jurisdiction. I. Constitutional matters. The court may only decide cases that involve constitutional issues, such as interpretation of the Constitution, the validity of legislation or executive conduct. 2. The interests of justice. The court considers whether hearing a case serves the public interest. 3. Issues connected with decisions on constitutional matters. Includes non-constitutional matters closely linked to constitutional disputes. 4. Supervisory and exclusive jurisdiction. AA. Expansion of the Constitutional Court's supervisory jurisdiction. The court may monitor compliance with its judgments. BB. Scope of the Constitutional Court's exclusive jurisdiction. Only the Constitutional Court may rule on disputes between organs of state, validity of constitutional amendments, dissolution of parliament. V. Functions of the Constitutional Court. Ensures that laws and government actions comply with the Constitution, confirms or invalidates unconstitutional laws. By composition and quorum of the Constitutional Court. 11 judges, with a quorum of 8 required for decisions. D. Constitutional jurisdiction of the Supreme Court of Appeal. Decides constitutional matters except those reserved for the Constitutional Court. E. Constitutional jurisdiction of the High Courts. May decide constitutional challenges in the first instance. Can declare laws invalid, but subject to Constitutional Court confirmation. F. Grant of interim relief by the Supreme Court of Appeal or a High Court in constitutional matters. High courts and the SCA may issue interim orders while awaiting a final decision. G. Constitutional jurisdiction of the magistrates' courts. Magistrates' courts cannot declare laws invalid but may interpret constitutional issues. 5.4 Access to the Constitutional Court. A. Matters with an exclusive jurisdiction. Cases falling under S. 167(4) of the Constitution, such as intergovernmental disputes. B. Confirmation of orders of invalidity. I. Scope and purpose of the confirmation power. Only the Constitutional Court can confirm declarations of invalidity made by lower courts. 2. Orders of invalidity of delegated legislation do not require confirmation. Only primary legislation requires confirmation, subordinate laws do not. 3. Status of pre-1994 provincial legislation. The Constitutional Court reviews laws enacted by former provincial governments. 4. Conduct of the President. The Constitutional Court has exclusive jurisdiction over challenges to the President's conduct. C. Appeals. I. Appeals against orders of invalidity of parliamentary or provincial legislation or conduct of the President. Appeals concerning invalid legislation or executive action go directly to the Constitutional Court. 2. Other appeals. A. The appeals procedure. Leave to appeal is required unless the case involves direct jurisdiction. B. Common criteria for the assessment of applications for leave to appeal. The case must involve a constitutional issue or be in the interests of justice. C. Appeals to the Constitutional Court from a high court. Allowed only in constitutional cases. D. Appeals to the Constitutional Court from the Supreme Court of Appeal. The SCA must have ruled on the case before the Constitutional Court hears the appeal. D. Direct access. Litigants may apply for direct access, but this is only granted in exceptional cases. 5.5 Special procedures in constitutional court litigation. A. Joinder. Courts may require additional parties to join a case if they have a direct interest. B. Admission of amici curiae. Third parties with a substantial interest in a case may be admitted to provide legal arguments. Next page. 5.1 The relationship between constitutional jurisdiction and remedies. Jurisdiction, the authority of a court to hear, determine, and resolve a matter. Civil matters, determines which court a litigant must approach. Criminal matters, determines if a court has the power to try an accused person. Differences in jurisdiction for constitutional matters. Direct application of the Constitution. A constitutional challenge typically involves a defendant arguing that the law under which they are charged violates the Bill of Rights. Remedy, declaration of invalidity, i.e., law declared inconsistent with the Constitution. Only certain courts can declare a law invalid, for example, high courts, Supreme Court of Appeal, and Constitutional Court. Magistrates' courts lack the jurisdiction to declare laws invalid. Civil matters. A litigant may challenge a law that imposes an obligation or burden as unconstitutional. This triggers the Constitution's jurisdictional rules regarding the invalidation of legislation. Indirect application of the Bill of Rights. A litigant argues for the development or reinterpretation of existing law in line with the Constitution. Example. A defendant in a defamation case argues that the common law does not adequately protect freedom of speech and should be developed accordingly. A court interprets a statutory provision in light of constitutional values. No jurisdictional limits on indirect application, but constitutional appeals follow a specific appeal path. Jurisdiction is linked to remedies sought. The appropriate court is determined by its power to grant the remedy requested. This chapter should be read with Chapter 8. Which focuses on remedies in constitutional litigation. _ 5.2 Structure of the judicial system. The power of courts to grant constitutional remedies depends on the judicial hierarchy established by the Constitution. A. The interim constitution. Judicial structure pre-1996. South Africa had a hierarchical court system since 1910. Supreme Court of South Africa. Appellate division plus provincial/local divisions. Lower courts, primarily magistrates' courts. Creation of the Constitutional Court. The interim constitution, 1993, retained the existing hierarchy but introduced the Constitutional Court. The Constitutional Court was equal in status to the Appellate Division, later the Supreme Court of Appeal. Division of jurisdiction between the Constitutional Court and the Appellate Division. Appellate Division. Final authority in non-constitutional matters. Constitutional Court, Final authority in constitutional matters. No appeals between these two courts. Appeal process under the interim constitution. Cases raising only constitutional issues direct appeal to the Constitutional Court. Cases raising only non-constitutional issues follow normal appeal process, appellate division. Cases raising both constitutional and non-constitutional issues. The appellate division first determines if the case can be resolved on non-constitutional grounds. If constitutional questions remain, the case is referred to the Constitutional Court. No cross appeals. No appeal from the appellate division to the Constitutional Court. No appeal from the Constitutional Court to the appellate division. Next. Page 5.2, B, the 1996 Constitution. I. A new hierarchy of courts. Retention of existing courts. All courts existing before the 1996 Constitution remained in place. However, the judicial structure was substantially altered. New hierarchy established by Section 166 of the Constitution. 1. Constitutional Court. 2. Supreme Court of Appeal, SCA 3. High Courts, including Courts of Appeal for High Courts. 4. Magistrates' Courts. 5. Other courts established by legislation, such as the Labor Court and Land Claims Court. Transitional provisions in Schedule 6, Item 16. The Constitutional Court and Supreme Court of Appeal continued as constitutional bodies. Appellate Division renamed the Supreme Court of Appeal. Provincial and local divisions of the old Supreme Court became high courts. Judges retained their positions but subject to rationalization, possible restructuring. Existing legal references to courts were updated to align with new court names. The 2001 Amendment Act renamed judicial leadership positions. President of the Constitutional Court, Chief Justice. Deputy President of the Constitutional Court, Deputy Chief Justice. Chief Justice, President of the Supreme Court of Appeal. Deputy Chief Justice, Deputy President of the Supreme Court of Appeal. Jurisdictional changes under the 1996 Constitution. Constitutional Court. Final authority on constitutional matters must confirm declarations of invalidity made by high courts and the Supreme Court of Appeal regarding acts of Parliament, provincial legislation, or presidential conduct. Has original jurisdiction in certain constitutional cases. Supreme Court of Appeal, SCA. Former Appellate Division, now an independent constitutional body. Hears all appeals, including those with both constitutional and non-constitutional issues. High Courts. Replace the provincial/local divisions of the Supreme Court and Superior Courts of former TBBC states. Superior Courts with jurisdiction limited to geographical areas. Magistrates' Courts. No significant changes under the 1996 Constitution. Other specialized courts. Labor Court and Labor Appeal Court, Labor Relations Act 66 of 1995. Land Claims Court, Restitution of Land Rights Act 22 of 1994. Next. Page 5.2, C. Rationalization of the Superior Court structure. Subitem 6 of Item 16 of Schedule 6 required rationalization of courts inherited from apartheid-era structures. Rationalization was delayed, leading to continued operation of high courts under old names. Superior Courts Bill 52 of 2003 proposed restructuring but was withdrawn. Superior Courts Bill 7 of 2011 was introduced but was still under consideration at the time. Key proposal. Establish 9 High Court divisions, 1 for each province. Create a new Mpumalanga High Court, with its seat in Nelspruit. Each division may have local seats, determined by the Minister of Justice with the Judicial Service Commission. Renaming of High Courts Act 30 of 2008. Address delayed renaming of high courts. Updated names as follows. Old name and seat, new name and seat. Ciskei High Court, Bisho. Eastern Cape High Court, Bisho. Orange Free State Provincial Division, Bloemfontein Free State High Court, Bloemfontein. Cape of Good Hope Provincial Division, Cape Town Western Cape High Court, Cape Town. Durban and Coastal Local Division, Durban KwaZulu-Natal High Court, Durban. Eastern Cape Provincial Division, Grahamstown Eastern Cape High Court, Grahamstown. Witwatersrand Local Division, Johannesburg South Gauteng High Court, Johannesburg. Northern Cape Local Division, Kimberley Northern Cape High Court, Kimberley. Northwest High Court, Mafeking Northwest High Court, Mafeking. Transkei General Division, Umtata Eastern Cape High Court, Umtata. Natal Provincial Division, Pietermaritzburg KwaZulu-Natal High Court, Pietermaritzburg. Eastern Cape Local Division, Port Elizabeth Eastern Cape High Court, Port Elizabeth. Transvaal Provincial Division, Pretoria North Gauteng High Court, Pretoria. Venda High Court, Thohoyandou Limpopo High Court, Thohoyandou. _ 5.3 Jurisdiction in Constitutional Litigation. A. Jurisdiction of the Constitutional Court, Section 167, highest court in all constitutional matters. Decides only constitutional matters and related issues. Has final authority to determine what is a constitutional matter. Exclusive jurisdiction over disputes between organs of state and national/provincial spheres. Constitutionality of bills, as per Chapter 406. Whether Parliament or the President failed constitutional duties. Certification of provincial constitutions, Section 144. Final authority on the validity of acts of Parliament, provincial acts, and presidential conduct. Must confirm any order of invalidity issued by the SCA or High Courts. Direct access/appeals to the court allowed if it is in the interests of justice. Leave to appeal is granted. Definition of constitutional matter: any issue involving the interpretation, protection, or enforcement of the Constitution. B. Proposed amendments. Constitution 17th Amendment Act, 2012, Parliament passed and the President assented to the Constitution 17th Amendment Act, 2012. At the time, the Act had not yet commenced. Key changes to Section 167(3). Constitutional Court becomes the highest court in all matters, not just constitutional ones. The court may decide constitutional matters. Any other matter, if leave to appeal is granted based on an arguable point of law of general public importance. The court decides its own jurisdiction. Significance of the amendment: the court will no longer be a specialist constitutional court. It will hear appeals on legal issues of public importance. The new arguable point of law test functions similarly to the current interests of justice test for access to the court. Next page. Rationalization of the Superior Court structure. Subitem 6 of Item 16 aims to rationalize the Superior Court structure inherited from apartheid, based on old provinces and TBVC territories. Superior Courts Bill 52 of 2003 proposed significant changes, including the repeal of outdated acts like the Supreme Court Act 59 of 1959. Superior Courts Bill 7 of 2011, a redrafted version introduced, under consideration by the National Assembly. Proposed changes: High Court divided into 9 divisions, 1 per province. Creation of a new High Court for Mpumalanga, seat in Nelspruit. Local seats determined by the Minister and Judicial Service Commission. Renaming of High Courts Act 30 of 2008. Renamed various high courts to align with the new structure. Example: Transvaal Provincial Division, Pretoria North Gauteng High Court, Pretoria. Jurisdiction in constitutional litigation. A. Jurisdiction of the Constitutional Court, Section 167 of the Constitution. Highest court in constitutional matters. Decides only constitutional matters, including disputes between organs of state, national/provincial. Constitutionality of parliamentary/provincial bills. Whether Parliament or the President failed the constitutional duty. Certification of provincial constitutions, S-144. Final authority on constitutionality of legislation and presidential conduct. Direct access possible if, in the interest of justice, leave is granted by the court. B. Constitution 17th Amendment Act, 2012, expands the Constitutional Court's jurisdiction beyond constitutional matters. Changes to S-167(3). Previously, court could only hear constitutional matters. After amendment, becomes the highest court in all matters. Can hear any matter raising an arguable point of law of general public importance. Practical effect: formalizes the de facto position that constitutional and non-constitutional matters often overlap. Court retains discretion on access via interests of justice and arguable point of law standards. Criteria governing constitutional court's jurisdiction. I. Constitutional matters. Definition: S-167(7). Any issue involving the interpretation, protection, or enforcement of the Constitution. Key principles from case law. Pharmaceutical manufacturer's case. All exercises of public power must comply with the Constitution. Any challenge to public power's validity falls under constitutional jurisdiction. S.V. Bozek. Jurisdiction includes inconsistency of law or conduct with the Constitution, S-172-1A, S-167-4A. Status, powers, and functions of an organ of state. Interpretation and application of the Bill of Rights, S-39-2. Extradition cases, constitutional due to the impact on personal rights. Ordinary statutory interpretation, only constitutional if it raises different reasonable interpretations, one more aligned with the Bill of Rights. Limits to jurisdiction. Factual disputes alone do not constitute constitutional matters. Straightforward application of law, without constitutional concerns, is not a constitutional issue. _ S. V. Bozak and the limits of constitutional jurisdiction. Background. Bozak was convicted of fraud and theft. High Court sentenced him to 6 years, SCA reduced it to 3 years. He sought Constitutional Court appeal, arguing 1. Errors in evaluating evidence violated the presumption of innocence, S-35-3H. 2. Conviction without proper evaluation was a deprivation of freedom without just cause, S-12-1A. Constitutional Court's reasoning. Errors in fact-finding are not constitutional issues. Finality in criminal matters lies with the SCA, unless a constitutional question arises. Categories of constitutional matters in criminal cases. 1. Errors in factual assessment not constitutional. 2. Development, or lack thereof, of common law can be constitutional, for example, if inconsistent with S-39-2. 3. Application of law can be constitutional, for example, if inconsistent with a constitutional principle. Significance. Clarified pharmaceutical manufacturers by affirming that not all public power challenges are constitutional matters. Ordinary application of criminal procedure and evidence does not automatically raise constitutional concerns. Next page. Constitutional Court's jurisdiction. I. Constitutional matters. Specialist Court. The Constitutional Court is not a court of general jurisdiction but is the final authority on constitutional matters. Definition. S-167-7, includes issues involving the interpretation, protection, or enforcement of the Constitution. Distinction from other matters. Pharmaceutical manufacturer's case, all public power must comply with the Constitution, meaning any challenge to its exercise is a constitutional matter. S. V. Bozak, the Constitutional Court has jurisdiction over S-172-1A and S-167-4A. Reviewing laws and conduct for constitutional consistency. S-167-7, interpretation, application, and enforcement of the Constitution. S-39-2, indirect application of the Bill of Rights, including statutory interpretation and common law development. Legislation giving effect to constitutional rights. Issues related to such legislation are constitutional matters. Extradition. The validity of extraditing a South African citizen is a constitutional matter due to its impact on constitutional rights. Statutory interpretation. A constitutional matter arises only if the provision has two reasonable interpretations, with one more constitutionally compliant. Exclusions. Purely factual matters are not constitutional. Straightforward legal applications that do not question a law's validity or interpretation under constitutional principles are not constitutional. Criminal cases and constitutional matters. S. V. Bozak, the Constitutional Court clarified its jurisdictional limits. Grounds for appeal. High Court and SCA allegedly misinterpreted facts, violating S-35-3H, presumption of innocence, and S-12-1A, freedom deprivation without just cause. Court's holding. 1. Errors in fact-finding do not constitute constitutional matters. 2. Development, or failure, of common law by the SCA may be a constitutional matter if inconsistent with S-39-2. 3. Application of a legal rule is a constitutional matter if inconsistent with the Constitution. Key takeaway: not all public power challenges are constitutional matters, only those questioning the validity or interpretation of law under constitutional principles. _ 2. The interests of justice. Access to the Constitutional Court, even if a case involves a constitutional matter, it must also be in the interests of justice for the court to hear it. Principle of avoidance. If a case has both constitutional and non-constitutional issues, the court must resolve the non-constitutional issues first where possible. _ 3. Issues connected with decisions on constitutional matters. 1996 Constitution shift. Previously, only constitutional issues within a case fell under the Constitutional Court's jurisdiction. The 1996 Constitution broadened this to include constitutional matters as any issue concerning the Constitution's interpretation or application. AlixCorp Limited v. Reitersfeld Community, key case defining issues connected with decisions on constitutional matters. Land Restitution Act, enacted to fulfill constitutional rights, making its interpretation a constitutional matter. Issues beyond the Act, questions of historical land rights, before 1913, were not constitutional matters but were considered as connected issues necessary for deciding the main constitutional question. Rationale, excluding logically related issues would be artificial and hinder constitutional adjudication. S. V. Bassan, a trial judge's recusal issue was deemed connected to a constitutional matter, as the legal and factual issues impacted the constitutional question. Costs in constitutional cases. The award of costs in a constitutional matter is itself a constitutional issue, giving the Constitutional Court jurisdiction over cost-related appeals. Next page. Jurisdiction and functions of the Constitutional Court. 2. The interests of justice. A case must be classified as a constitutional matter due to the limited jurisdiction of the Constitutional Court. Even if a case raises constitutional matters, it must also be in the interests of justice to be heard by the court. Not all constitutional questions warrant the court's attention. The principle of avoidance dictates that non-constitutional issues must be resolved first when possible. 3. Issues connected with decisions on constitutional matters. Under the interim constitution, the terms matter and issue were distinguished, with the court having jurisdiction only over constitutional issues. The 1996 Constitution broadened this view. Any issue related to the interpretation or application of the Constitution is a constitutional matter. Section 167(3)(b). The court may also consider issues connected to constitutional matters, even if they are not directly constitutional. AlixCorp Limited v. Reitersfeld Community concerned a land restitution claim under the Restitution of Land Rights Act. Constitutional Court ruled that questions regarding interpretation and application of legislation enacted to give effect to constitutional rights are constitutional matters. Questions of historical land rights were not constitutional matters but were connected issues. The court reasoned that excluding such considerations would be artificial and arbitrary. S. V. Bassan. Legal and factual issues required to decide a constitutional question are issues connected with a constitutional matter. Award of costs in a constitutional matter is also a constitutional issue. 4. Supervisory and exclusive jurisdiction. Supervisory jurisdiction. The court hears appeals and confirms decisions of the High Court and Supreme Court of Appeal. Exclusive jurisdiction. Certain matters can only be decided by the Constitutional Court. A. Expansion of supervisory jurisdiction. Under the interim constitution, the court had exclusive jurisdiction over acts of parliament, constitutionality of bills, abstract review, disputes between national organs of state. The 1996 Constitution changed this. Jurisdiction over constitutional challenges to legislation is now concurrent between the Constitutional Court, Supreme Court of Appeal, and High Courts. Confirmation requirement, S. 167(5). Any declaration of invalidity by the SCA or High Court regarding an Act of Parliament, Provincial Act, or presidential conduct must be confirmed by the Constitutional Court. Zansi v. Council of State, SISK, former TBVC Homeland legislation is not considered an Act of Parliament or Provincial Act, so High Courts and the SCA can declare it invalid without Constitutional Court confirmation. VB, scope of exclusive jurisdiction. The Constitutional Court has exclusive jurisdiction over disputes between organs of state, national/provincial, on constitutional status, powers, or functions. Constitutionality of provincial or parliamentary bills. Challenges to constitutional amendments. Deciding whether Parliament or the President has failed the constitutional duty. Certification of provincial constitutions. President of RSAV Sarfu. A broad reading would make almost all constitutional challenges fall under exclusive jurisdiction. A narrower interpretation is required to preserve the jurisdiction of high courts and the SCA. Doctors for Life and King v. Attorneys Fidelity Fund Board of Control. Challenges to an act of parliament based on lack of public participation fall within exclusive jurisdiction. Constitutional matters like Bill of Rights violations or manner and form issues do not. V. Functions of the Constitutional Court. The court primarily acts as an appellate court for constitutional issues. 4 main functions. 1. Exclusive jurisdiction, resolving disputes over state organs, amendments, and legislative compliance. 2. Direct access, exceptional cases, in urgent and important cases, direct access may be granted. 3. Appeals on constitutional matters, from high courts and the Supreme Court of Appeal. 4. Confirming orders of invalidity, the court must confirm orders declaring an act of Parliament, provincial legislation, or presidential conduct invalid. Underscore. By composition and quorum of the Constitutional Court. The court consists of Chief Justice, Deputy Chief Justice, 9 additional justices. The court usually sits on bank with a minimum quorum of 8 judges. A decision requires a majority vote. If no majority is reached, the case is dismissed. Judicial appointments. The President appoints justices based on recommendations from the Judicial Service Commission. Acting justices may be appointed in case of vacancies but not due to recusal of sitting justices. Next page. Constitutional jurisdiction of courts in South Africa. D. Constitutional jurisdiction of the Supreme Court of Appeal, SCA, Interim Constitution. Established a strict separation of jurisdiction between appellate courts. Appellate Division, Final Court for non-constitutional matters. Constitutional Court, Final Court for constitutional matters. Section 101(5) of the Interim Constitution denied the Appellate Division constitutional jurisdiction. No appeals between the two courts. 1996 Constitution. Supreme Court of Appeal, SCA, replaced the Appellate Division. SCA has jurisdiction over constitutional issues. Section 167(5). SCA can declare legislation invalid on constitutional grounds, but its ruling requires confirmation by the Constitutional Court. Hierarchy. SCA is the final court for non-constitutional matters. Constitutional Court is the final court for constitutional matters. Appeal routes. Constitutional matters may bypass the SCA and go directly from the High Court to the Constitutional Court. If the SCA hears a constitutional issue, a further appeal to the Constitutional Court is possible. E. Constitutional jurisdiction of the High Courts. High Court's jurisdiction in constitutional matters can decide any constitutional issue unless it falls under the exclusive jurisdiction of the Constitutional Court. Can declare legislation or conduct invalid, but orders affecting Parliament, provincial legislation, or the President must be confirmed by the Constitutional Court. Jurisdiction in non-constitutional matters. Derived from national legislation. Section 173, Inherent Powers. High Courts, SCA, and Constitutional Court have inherent power to regulate their own process, develop the common law, prevent abuse of process. This power does not limit entrenched rights but ensures the effective administration of justice. F. Grant of interim relief by the SCA or High Court in constitutional matters. Section 172(2)(b). Courts making an order of constitutional invalidity may grant temporary interdicts or other relief. Adjourn proceedings pending a final ruling by the Constitutional Court. Purpose of interim relief. Prevents prejudice caused by enforcement of possibly unconstitutional legislation. Typically involves interdicts preserving the status quo. Common in cases involving national or provincial legislation and presidential conduct. Criteria for granting interim relief. Balance of convenience. Weighs applicants' interests, respondents' interests, and the public interest. Separation of powers concerns. Courts should be cautious when interfering with the functions of state organs. Jurisdiction of high courts in exclusive matters of the Constitutional Court. In urgent matters, a high court may grant interim relief even in cases under the exclusive jurisdiction of the Constitutional Court. A high court cannot make a final determination on exclusive Constitutional Court matters but may grant temporary relief. President of the Republic of South Africa v. United Democratic Movement. Considered the validity of a high court order suspending legislation. Findings. Courts should grant interim relief only when necessary to prevent irreparable harm. Courts should not suspend the operation of legislation unless strictly required. Interim relief must not decide on the constitutionality of legislation. In cases involving constitutional amendments, interim relief should be minimally intrusive. Underscore. This summary covers the constitutional jurisdiction of the Supreme Court of Appeal, High Courts, and their power to grant interim relief in constitutional matters. Let me know if you need further refinements or case law details. Next. Page. Would you like me to summarize another section or provide further clarification on any of the points? Next. Page. Constitutional jurisdiction of magistrates' courts. Section 170 of the Constitution. Magistrates' courts and all other courts may decide matters as determined by an act of Parliament. However, courts lower than the High Court may not inquire into or rule on the constitutionality of any legislation. Inquire into or rule on the conduct of the President. Scope and limitations of magistrates' courts' constitutional jurisdiction. No jurisdiction to enforce the Constitution directly unless conferred by legislation. Cannot rule on the validity of any legislation, includes original legislation, parliamentary, provincial, municipal laws, delegated legislation, proclamations, regulations, rules. Common law may be granted jurisdiction by an act of Parliament to inquire into the validity of administrative action, excluding delegated legislation and presidential conduct. Common law, customary law. Magistrates' Courts Act 32 of 1944, Section 110, before amendment, magistrates' courts could rule on the validity of statutory regulations, orders, and bylaws. Could declare ministerial regulations invalid if ultra vires, beyond legal authority. Other common law administrative law grounds. Magistrates' Courts Second Amendment Act 80 of 1997, amended Section 110, 110(1). Magistrates' courts cannot rule on the validity of any law, including original and delegated legislation. The conduct of the President. 110(2). If an allegation is made that a law or presidential conduct is invalid, the magistrate must assume the law or conduct is valid. However, evidence relating to invalidity may be heard. Litigants must appeal to the High Court to pursue constitutional challenges. Implications. Raises costs and procedural difficulties. High Court may need to refer cases back for further evidence. Interaction with the Promotion of Administrative Justice Act, PHA, 3 of 2000. PAHA grants magistrates' courts jurisdiction for judicial review of administrative action, if designated by the minister. Scope of jurisdiction under PAHA. Magistrates' courts can rule on the validity of administrative action. Administrative action, as defined in PAHA S1, may include delegated legislation. Does not include conduct of the President. PAHA does not confer constitutional jurisdiction but allows testing of legislative or executive actions on statutory grounds. Distinction between direct and indirect constitutional application. Magistrates' courts may not directly apply the Bill of Rights to declare laws invalid. Magistrates' courts may indirectly apply the Bill of Rights through interpretation of legislation. Develop common law in accordance with the Bill of Rights. Doctrine of precedent. Bound by superior court rulings, even if inconsistent with the Constitution. Pre-1994 common law precedents remain binding unless they conflict with the Constitution. Practical implications of limited constitutional jurisdiction. Cannot grant relief in disputes over the validity of laws or presidential conduct. Still bound to uphold constitutional rights, particularly fair trial rights in criminal proceedings. Ensuring procedures align with constitutional principles. Next page. Access to the Constitutional Court. A. Matters within exclusive jurisdiction. The Constitutional Court has exclusive jurisdiction over certain matters, discussed earlier. Rules 14, 15, and 17 of the 2003 rules set procedures for bringing three types of matters. Rule 14, referral of a parliamentary or provincial bill, S79 4b, S121 2b. Rule 15, applications on constitutionality of an act brought by legislature members, S81, S122 1. Rule 17, certification of a provincial constitution. No specific procedure exists for disputes between national/provincial organs of state, S167 4a. Constitutionality of constitutional amendments, S167 4d. Failure of Parliament/President to fulfill a constitutional obligation, S167 4e. Such matters must follow the general application procedure, Rule 11. B. Confirmation of orders of invalidity. I. Scope and purpose of the confirmation power. The Constitutional Court must confirm any order of constitutional invalidity regarding parliamentary/provincial legislation. Conduct of the President. Purpose: ensuring the highest constitutional authority controls invalidity declarations affecting top state organs. Section 172 2c requires national legislation to regulate referrals of invalidity orders. Constitutional Court Complementary Act 13 of 1995, amended in 1997, governs referrals. Section 81a, orders of invalidity from the Supreme Court of Appeal, SCA, High Courts, or similar courts must be referred to the Constitutional Court. Referral is mandatory, not optional. Rule 16(1). Registrar of the issuing court must lodge the invalidity order with the Constitutional Court Registrar within 15 days. Interested parties may apply for confirmation or appeal the invalidity order. If no appeal/confirmation application is made, the Chief Justice issues directions on disposal. Key distinctions. Confirmation proceedings does not equal appeal or direct access. No need for additional arguments/evidence at the Constitutional Court. Decision based on record of lower court proceedings. Ministers responsible for legislation must be given an opportunity to intervene at the lower court. Section 8(2) allows the Constitutional Court to request ministerial arguments on specific issues. The court is not bound to confirm invalidity orders. Conducts an independent constitutional assessment regardless of party positions. May vary, refuse, or decline to hear confirmation applications. 2. Orders of invalidity of delegated legislation do not require confirmation. Only Acts of Parliament and provincial acts require confirmation. Delegated legislation, for example, regulations by ministers or MECs, does not require confirmation. Even if definition sections state that this act includes regulations, confirmation is not required. Key principle: confirmation jurisdiction applies only to original legislation, not rules from delegated authority. 3. Status of pre-1994 provincial legislation. Historical background. Pre-1994 provincial councils had limited legislative powers. Their legislation, provincial ordinances, was later downgraded to delegated legislation by the Provincial Government Act 69 of 1986. Some of these ordinances remain in force. Issue are pre-1994 ordinances provincial acts requiring confirmation. Where case. The court ruled that the KwaZulu-Natal Regulation of Racing and Betting Ordinance 28 of 1957 is a provincial act for confirmation purposes. Rationale: post-1994 legislative action, amendment/incorporation, granted the ordinance democratic legitimacy. Unresolved question: ordinances not considered post-1994 may not require confirmation. TBVC states old order legislation is treated as an act of Parliament for confirmation purposes. 4. Conduct of the President. Scope of conduct of the President. Unclear but excludes. Failure to fulfill a constitutional obligation, S-167 4E. Actions where authority is residual, minister primarily responsible. Administrative actions, governed by the Promotion of Administrative Justice Act. Delegated lawmaking actions, for example, proclamations. Von Abo case. Executive actions by ministers are not considered conduct of the President. Prevents unnecessary confirmation proceedings. Pre-1994 heads of state. Mosenenke case raised but did not resolve whether conduct of the President includes apartheid-era state presidents or governor-generals. _ Key takeaways. Exclusive jurisdiction cases have specific rules, Rules 14, 15, 17, or follow general application procedures. Rule 11. Orders of invalidity require confirmation only if they involve original legislation or presidential conduct. Delegated legislation and pre-1994 ordinances, without post-1994 amendments, likely do not require confirmation. The Constitutional Court independently assesses invalidity orders and may vary, refuse, or decline confirmation. Presidential conduct for confirmation purposes excludes failures to act, administrative actions, and delegated lawmaking. Next page. Appeals to the Constitutional Court. 1. General principles. The Constitutional Court, CC, primarily functions as an appellate court, hearing constitutional issues from the High Court, HC, or Supreme Court of Appeal, SCA. Appeals fall into two categories. Appeals against orders of invalidity, S-172(2)A of the Constitution. Other appeals. The CC does not have to provide reasons for rejecting applications for leave to appeal. _ 2. Appeals against orders of invalidity. Jurisdiction. HC and SCA can declare laws or conduct unconstitutional, except matters under S-167(4) of the Constitution. Invalidity of parliamentary/provincial legislation or conduct of the President must be confirmed by the CC to be effective. Process, S-172(2)D. Any person or organ of state with sufficient interest can appeal directly to the CC to confirm/vary an order of constitutional invalidity. If the HC declares national/provincial legislation or presidential conduct invalid, the appeal goes directly to the CC without passing through the SCA. No leave to appeal is required in such cases. Rule 16, Procedure for Direct Appeals under S-172-2D. File a notice of appeal with the Registrar of the CC and the Registrar of the HC. Notice must state grounds of appeal in the desired order. _ 3. Other appeals. A. Appeals Procedure. S-167-6B of the Constitution. National legislation or CC rules must allow a person to appeal directly to the CC, when it is in the interests of justice and with leave of the CC. Rule 19. Appeals from any court including the SCA. Application for leave to appeal must be lodged within 15 days of the contested order. Respondents can consent or oppose the application. CC considers the application and any cross appeals before granting leave. Simultaneous applications. A litigant can apply for leave to appeal to both the CC and another appellate court, SCA or full bench of HC. If the CC refuses, the appeal can proceed to the SCA or full bench. If the HC or SCA grants leave to appeal, it may be conditional on CC refusing leave. If CC refuses leave, the litigant can reapply after the SCA decision. Decision-making process. CC decides on leave at a conference with at least 8 justices. Application is refused if a majority finds no reasonable prospect of success. Interests of justice are the primary factor in granting leave. Oral hearings may be held in some cases. Who may appeal? Rule 19(2) allows any aggrieved litigant to seek leave to appeal. State organs, for example, DPP, can appeal under Rule 19 if they have a substantial interest. Aggrieved means a litigant must have a direct and substantial interest in the issue. _ 4. Criteria for leave to appeal. 1. Interests of justice, S-167-6. Prospects of success are important but not decisive. Even a strong case may be rejected based on broader interests of justice. No leave is granted if no reasonable prospect of success. 2. Nature of the constitutional issue. Appeals must involve constitutional matters or be linked to a constitutional issue. Issues of public importance are more likely to be heard. Novelty of the issue is a factor. Appeals against interim orders are possible if they have immediate, substantial, and irreparable effects. 3. Prior consideration by lower courts. CC avoids acting as a court of first instance. Issues not raised in lower courts are unlikely to be considered. Cases involving common law development should generally be heard by the SCA first. CC is reluctant to consider appeals with disputed factual issues. 4. Procedural compliance. Compliance with joinder and notice requirements is essential. If the relevant state organ was not involved in lower court proceedings, leave to appeal may be denied. 5. Hypothetical cases. CC does not hear cases where the dispute is no longer live. 6. Litigation between state organs. The principle of cooperative government requires state organs to exhaust other dispute resolution mechanisms before litigating. CC rarely grants leave in disputes between state organs if alternative resolution methods were not attempted. 7. Recusal of justices. If a case would require recusal of a majority of justices, CC may refuse leave. _ 5. Appeals from the High Court. Additional considerations. Delays and costs of an intermediate appeal affect the interests of justice. If a case involves the direct application of the Constitution, a direct appeal to CC may be justified. If a case involves common law development, the SCA should hear it first. Mixed appeals, constitutional plus non-constitutional issues, should go to SCA or full bench. Interlocutory rulings with no final effect are rarely considered. Summary of appeal paths. 1. Orders of invalidity, national/provincial legislation or president's conduct, direct to CC, no leave required. 2. Orders declaring such legislation/conduct valid or other constitutional issues direct to CC with leave required. 3. Non-constitutional matters SCA or full bench. 4. Matters involving indirect Bill of Rights application SCA or full bench. 5. Mixed appeals, constitutional plus non-constitutional issues, SCA or full bench. _ 6. Appeals from the Supreme Court of Appeal. Governed by Rule 19, CC hears appeals only on constitutional matters. CC can consider refusals by SCA to grant leave to appeal in constitutional cases. _ Key takeaways. Orders of invalidity, national/provincial legislation or presidential conduct, go directly to CC. All other constitutional appeals require CC leave and must serve the interests of justice. CC avoids cases that lack reasonable prospects of success, were not raised in lower courts, are hypothetical or moot. Mixed or common law-related issues should first go to the SCA. State organs must exhaust cooperative dispute resolution before litigating. Next page. Direct access to the Constitutional Court. Definition: direct access allows a matter to be heard by the Constitutional Court, CC, at first instance, despite it being primarily an appellate court. Constitutional provision. Section 167(6)(a). National legislation or CC rules must allow a person, when in the interests of justice and with leave of the CC, to bring a matter directly to it. Rules for direct access. Direct access is an extraordinary procedure, granted in very limited cases. The rules of the CC allow direct access in cases where the CC exercises concurrent jurisdiction. The matter is of sufficient public importance or urgency, making direct access in the interests of justice. With the 1996 Constitution, direct access in concurrent jurisdiction cases is largely unnecessary due to the expanded constitutional jurisdiction of high courts. Historical approach. Under the interim Constitution, 1995 rules, direct access was only granted in exceptional circumstances, such as urgency or public importance, where ordinary procedures would prejudice public interest or justice. The CC consistently held that direct access should be granted only in rare cases. Bruce v. Fleecitex. The 1995 rules and their interpretation aligned with the interests of justice requirement in Section 167(6). The CC raised concerns about unrestricted direct access. It could lead to the CC dealing with disputed facts requiring evidence. Some cases could involve constitutional issues that are not decisive or are of academic interest. The CC could hear cases without prior judgments from other courts, limiting judicial reasoning. Justice is not ordinarily served by a court acting as the first and last instance, as there would be no avenue for appeal. Application requirements. Rule 18. The application must explain why direct access is in the interests of justice. Specify the relief sought and the grounds for such relief. The CC has ruled that challenging the validity of an act is insufficient for direct access. Public interest prejudice must be proven. Environmental harm alone does not justify direct access under Rule 18. Factors considered by the CC. 1. Prospects of success. Direct access is unlikely if an applicant has a weak substantive case. The applicant must present at least a prima facie case and specify the relief sought. Compliance with notice and joinder rules is required. 2. Exhaustion of other remedies. Direct access is unlikely if alternative remedies exist. High courts and the Supreme Court of Appeal have constitutional jurisdiction, including declaring acts invalid, subject to CC confirmation, granting temporary interdicts pending CC decisions. The CC will only consider direct access if there are compelling reasons to bypass these procedures. Cooperative government and state litigation. Constitutional principle of cooperative government. Organs of state must attempt to settle disputes amicably and avoid litigation. The CC is unlikely to grant direct access in disputes between state entities unless they comply with these principles. Handling of evidence and variations. The CC does not generally act as a trial court or hear oral evidence to resolve factual disputes. Direct access is appropriate for applications to vary a CC order. Next page. Special procedures in constitutional court litigation. A. Joinder. Applicants must provide notice of challenges to the constitutionality of an executive act/conduct to the responsible executive authority if they are not a party. The minister or MEC responsible for the administration of the law must have a fair opportunity to respond. This requirement is based on fairness in litigation. Valuable input the executive authority may provide. Judicial respect for other branches of government. Failure to join or notify the appropriate authority may lead to the Constitutional Court declining to hear the case if it results in prejudice to the state. Relevant cases. B&Ash. Failure to join the Minister of Justice contributed to the rejection of an application for direct appeal. Used to be Score Supermarket Trading, Proprietary, Limited. The Minister of Labor was not notified in the High Court challenge to the Compensation for Occupational Injuries and Diseases Act 130 of 1993. The CC noted that failure to give notice could be a basis to refuse confirmation of invalidity, but in this case, confirmation was denied on substantive grounds without prejudice to the state. B. Admission of amicus curiae. A person not a party to a case but with an interest in it may be admitted as an amicus curiae. Definition: Hoffman v. South African Airways. Assists the court by providing information or legal arguments. Not a litigant but has an interest in the outcome. Different from an intervening party, who has a direct legal interest and participates as a party. The amicus acts as a friend of the court and may support one side unless directed otherwise by the court. Procedures for admission. Written submissions only, limited to the appeal record or referral. Facts proved in other proceedings. Technical, scientific, statistical, or official facts. Rule 31. 2 methods of admission. 1. With consent of all parties. The amicus must obtain written permission from all parties, agreeing on terms and conditions. If granted, the Chief Justice admits the amicus, subject to any directions. 2. Without consent. The amicus applies directly to the Chief Justice, who exercises discretion. Principles for admission. The amicus must have an interest in the case, raise new, relevant arguments beneficial to the court, aim to assist the court in achieving justice, rather than serving partisan interests. Foe's case, the Human Rights Commission was denied admission as an amicus because it failed to add new arguments. Limitations on amicus curiae. Cannot introduce a new cause of action in an appeal unless permission is granted by the Chief Justice. Such permission is unlikely if it requires adding new parties. It prejudices any of the existing parties. Next page. Chapter 6, Interpretation of the Bill of Rights. 6.1 The stages of interpretation. Interpretation of the Bill of Rights involves multiple stages, ensuring that constitutional rights are understood, applied, and developed in accordance with the values of the Constitution. The process requires courts to consider the text of the provision, the purpose of the right, the historical, political, and textual context, the broader framework of constitutional values. 6.2 Interpretation of the Bill of Rights. Interpretation is aimed at ensuring that rights are meaningful and effective. Courts must adopt an approach that enhances constitutional values. The Constitutional Court has emphasized that the Bill of Rights should be interpreted expansively, not narrowly. 6.3 The point of interpretation, a generous, purposive, and contextual approach. The Bill of Rights must be interpreted generously, maximizing the protection of rights. Purposively, giving effect to the intended purpose of the right. Contextually, considering historical, political, and textual factors. A. The role of the text. The text of the Constitution is the starting point for interpretation. However, a literal approach is insufficient. Meaning must be derived in light of constitutional values and principles. B. Purpose of interpretation. Interpretation must seek to realize the purpose of the right in question. Courts look at why the right exists and interpret it in a way that best serves its objectives. C. Generous interpretation. Rights must be interpreted expansively rather than narrowly. A strict or technical interpretation that limits rights is inconsistent with constitutional values. D. Context. Context is critical in interpreting the Bill of Rights. Courts must consider both historical and textual context. I. Historical context. The Bill of Rights must be understood in light of South Africa's history of oppression and human rights violations. A. Political history. Apartheid and colonialism deprived individuals of fundamental rights. The Bill of Rights aims to correct past injustices and prevent future discrimination. B. Drafting history. Courts may consider the negotiation process that led to the adoption of the Constitution. However, the final text remains the primary guide. 2. Textual context. Interpretation should be consistent with the Constitution as a whole. Rights must be understood in relation to other constitutional provisions. 6.4 The Interpretation Clause. Section 39 of the Constitution sets out the framework for interpreting the Bill of Rights. A. Section 39(1), Guiding Principles. When interpreting the Bill of Rights, courts must 1. Consider international law. 2. May consider foreign law. 3. Promote the values of human dignity, equality, and freedom. B. Section 39(2), Developing the common law and legislation. Courts must promote the spirit, purport, and objects of the Bill of Rights when interpreting any legislation. The common law and customary law. The goal is to ensure that all laws align with constitutional values. C. Section 39(3), Rights beyond the Bill of Rights. The Bill of Rights does not limit or deny other rights that exist in common law, legislation, international law. 6.5 Other provisions of the Constitution. Other constitutional provisions also influence the interpretation of the Bill of Rights. Courts must read the Constitution holistically, ensuring consistency between different sections. Next. Always include these subheading numbers when writing the subheadings. Page. Got it. I'll always include subheading numbers in your study notes. Let me know if you need anything else. Next. Page. 6.1 The stages of interpretation. Constitutional interpretation determines the meaning of constitutional provisions, especially in Bill of Rights cases. 2 key inquiries. 1. Determining the meaning/scope of a right, focus of this chapter. 2. Assessing whether law/conduct conflicts with the right, separate inquiry. Rights may impose negative obligations, prevent infringement of protected activities. Positive obligations, require state action to fulfill rights. Interpretation involves defining the scope of protected activities or obligations. Example. Freedom of expression, S16, if pornography is protected, banning child pornography infringes the right. Right to vote, S19, if it requires arrangements for prisoner voting, failure to do so is a violation. The second inquiry assesses whether the law/conduct violates the right after interpreting its meaning. 6.2 Interpretation of the Bill of Rights. Constitutional meaning depends on context and can be subject to dispute. Some provisions are deliberately vague, due to political compromises, or abstract, Bill of Rights provisions. Key questions. What rules/methods apply to constitutional interpretation? Does the Constitution prescribe specific interpretative methods? Relevant provisions. Section 39 Interpretation Clause, Bill of Rights. Section 239 defines terms like national legislation and organ of state. Judicial role. Since the Constitution does not fully regulate its own interpretation, courts, especially the Constitutional Court, have established guidelines. Section 39, discussed in 6.4, provides key interpretative directives. 6.3 The point of interpretation, a generous, purposive, and contextual approach. Constitutional and Bill of Rights interpretation follows 3 principles. 1. Generous interpretation, broadly construing rights. 2. Purposive interpretation, understanding provisions based on their objectives. 3. Contextual interpretation, considering historical, political, and textual contexts. A. The role of the text. Starting point. Interpretation begins with the text itself. SV Zuma courts must respect the Constitution as a legal instrument, ensuring that values do not override textual meaning. Principles from SV Zuma and SV McQuanian. Interpretation must give due regard to the language of the Constitution. A generous and purposive approach must guide interpretation, emphasizing constitutional values. Literal meaning is not always decisive. It must align with the broader constitutional purpose. Courts have favored purposive interpretations over strict textual readings in multiple cases. Limits on interpretation. Courts cannot impose meanings that the text cannot reasonably bear. The interpretation must not be unduly strained. Next. Page. 6.3 The point of interpretation, a generous, purposive, and contextual interpretation. B. Purposive interpretation. Definition. Identifies the core values underlying fundamental rights in an open, democratic society based on human dignity, equality, and freedom. Prefers interpretations that best protect these values. Key judicial endorsements. R.V. Big M Drug Mart Limited, Canada. Rights must be interpreted in light of their purpose and the interests they protect. Consider historical origins, language, and associated rights within the constitutional framework. The approach should be generous, not legalistic, ensuring full benefit of constitutional protections. Application and Bill of Rights interpretation. The purpose of a right determines its scope. A law only infringes a right if it affects the values and interests the right is meant to protect. Example. Freedom of expression, S16. If its purpose is solely to encourage political debate, pornography may not be protected. If it also supports personal autonomy and self-fulfillment, pornography may be protected. Challenges in applying purposive interpretation. Requires value judgments on which rights and purposes are constitutionally significant. Values must be determined objectively by reference to national norms and aspirations, not public opinion. Judicial role in purposive interpretation. S.V. McQuanian, Abolition of the Death Penalty. Public opinion is relevant but not decisive in constitutional interpretation. Courts must protect minorities and vulnerable groups from majoritarian rule. If public opinion were decisive, rights protection could be left to Parliament, undermining judicial review. Courts have a duty to safeguard the worst and weakest among us. Conclusion. Purpose of interpretation acknowledges that value judgments are integral to constitutional interpretation. However, it does not prescribe a fixed method for making these judgments. Other principles, for example, generous and contextual interpretation, help clarify how value judgments should be made. C. Generous interpretation. Definition. Favors expansive protection of rights over restrictive readings. Rights should be interpreted as broadly as possible within the limits of the text and context. Judicial endorsements. S.V. Zuma cited Lord Wilberforce and Minister of Home Affairs, Bermuda, v. Fisher. Supreme constitutions require a generous interpretation to ensure individuals enjoy the full measure of rights and freedoms. Application in case law. S.V. Mlung. The court reaffirmed that a constitution is an organic, sui generis instrument requiring broad, liberal, and purposive interpretation. Purpose: to ensure the Constitution remains dynamic, protects national aspirations, and disciplines government. The majority applied generous interpretation to S. 241(8) of the interim Constitution, allowing pending cases to benefit from the new Bill of Rights, despite an apparently clear literal meaning to the contrary. Key takeaway. A literal approach is insufficient. A constitution must be read dynamically to achieve its transformative purpose. Next page. 6.4 Tension between generous and purposive interpretation. A. Minority and majority approaches in S.V. Mlung. Minority view, Kentridge H.A. The ordinary meaning of S. 241(8) should be followed. Limitations on generous interpretation. The Constitution must be interpreted within the language used. S. 241(8) explicitly states that pending cases should be handled as if the Constitution had not been passed. If the language is clear, it must be given effect, even if it leads to a narrower interpretation. Majority view. Preferred a broad interpretation where the text reasonably allows it. If a restrictive interpretation would deny individuals the benefits of the Bill of Rights, it should be avoided. Applied the principle that rights must be interpreted to their widest amplitude, as long as the text permits. B. Criticism of generous interpretation. Mlung does not explain why constitutional provisions should be given a generous interpretation. Potential issues. If other interpretative principles, for example, purpose of interpretation, suggest a narrower reading, a broad interpretation may distort the text. The majority's attempt to align generous interpretation with language and context is unclear. A generous reading may contradict purposive interpretation, which sometimes justifies a narrower scope. C. Resolving the conflict between generous and purposive interpretation. Possible explanations for generous interpretation. 1. Not just a distinction from statutory interpretation. It is not merely a reaction against narrow, legalistic statutory interpretation. Courts already recognize that constitutional interpretation is different from statutory interpretation. 2. Interaction with the limitation clause. A broad reading of rights at the interpretation stage allows courts to shift the burden onto the state to justify restrictions under the limitation clause. For example, S36 of the South African Constitution. Courts assume a right has been violated and require the government to justify its actions. Current approach of the Constitutional Court. The court has not fully adopted the limitation clause justification for generous interpretation. It does not expand rights indefinitely. Instead, it generally demarcates rights based on their purpose. When faced with a conflict between generous and purposive interpretation, the court appears to prioritize purposive interpretation. D. Conclusion. The limited role of generous interpretation. If the court always demarcates rights based on their purpose, generous interpretation does not play a significant role. Generous interpretation is secondary to purposive interpretation, which ultimately determines the scope of constitutional rights. Next page. 6.5 Context in constitutional interpretation. The meaning of words in the Constitution depends on their context. Context has two dimensions. 1. Wider context, the historical and political setting of the Constitution. 2. Narrower context, the textual context within the Constitution itself. A. Historical context. I. Political history. The Constitution is a reaction to South Africa's past, aiming to break from apartheid and establish a culture of openness, democracy, and universal human rights, Muhammad J. Constitutional interpretation must consider this historical context to avoid repeating past injustices. In Brink v. Kiteshoff now. The Equality Clause must be interpreted in light of South Africa's history of systematic racial discrimination. Apartheid laws excluded black South Africans from property ownership, jobs, education, and public amenities. The scars of this history remain visible and must inform how equality is understood and applied. 2. Drafting history. Statements by politicians during the drafting process, ipse dixit, hold little value in interpretation. S.B. McQuanian. Reasoning. The Constitution is the product of multiple actors, not just a few politicians or civil servants. Individual statements do not necessarily reflect the collective intent behind the Constitution. Distinction between political statements and official drafting records. Background materials, for example, reports from technical committees, are more useful. Similar to travaux préparatoires in international law, these documents provide context for interpretation. In S.B. McQuanian, background materials helped show that the framers deliberately left the right to life unqualified, allowing the Constitutional Court to decide the constitutionality of the death penalty. McQuanian criteria for using background materials. 1. Official recognition, must be an officially recognized document. 2. Clarity, content must be clear and undisputed. 3. Relevance, must be relevant to explaining why a provision was included or excluded. Impact of background materials. Although they provide useful context, they are not usually decisive in constitutional interpretation. Next page. Let me know if you'd like any refinements or additional details in your text. Next page. It looks like you have a duplicate document. Do you want me to merge, edit, or replace one of them? Next page. It looks like you've finalized your document. Let me know if you need any edits, additions, or refinements. Next page. Let me know if you need any edits, additional details, or refinements. Next page. It looks like you want this content incorporated into your document. I'll update it accordingly. Edited. I've incorporated the new section on the tension between generous and purposive interpretation into your document. Let me know if you'd like any refinements. Next page. I've added the continuation of section 6.3 on the tension between generous and purposive interpretation. Let me know if you need any refinements. Next. Start a different note in chat and not edit. Page. Next. Page. Here's a new note for you. Underscore. Tension between generous and purposive interpretation. 1. The debate on generous versus purposive interpretation. Minority view, Kentridge H.A., Mlung case, literal approach, the ordinary meaning of words should be followed. Limits on generous interpretation, the language of the Constitution itself sets limits. Application to S. 241A to the Interim Constitution. It explicitly states that pending cases should be handled as if the Constitution had not been passed. When language is clear, it must be applied as written. Majority view, Mlung case, broader interpretation preferred. A narrow reading would deny individuals the benefits of the Bill of Rights. Interpretation should favor the widest possible protection of constitutional rights. Condition for broad interpretation. Must be supported by the language and context of the Constitution. 2. Challenges of generous interpretation. Potential for strained interpretation. The majority in Mlung insisted on adherence to text and context, yet a broad interpretation may still lead to straining the meaning of provisions. Conflict with purposive interpretation. A constitutional provision's purpose may be narrow. A broad reading could contradict the intended objective. The Constitutional Court has not explicitly resolved this tension. 3. Justifications for generous interpretation. Rejection of statutory interpretation methods. Constitutional law differs from statutory law, not constrained by parliamentary supremacy. However, this does not fully explain why generosity is necessary. General Limitation Clause justification. South African and Canadian constitutions include limitation clauses. Courts can adopt a broad interpretation first, then require the government to justify any infringement. Shifts the burden to the state, not the individual. 4. The Constitutional Court's approach. Not fully committed to generous interpretation. The court is hesitant to extend constitutional protections to an indefinite number of activities. When conflict arises, the court tends to favor purposive interpretation over generous interpretation. Implication. If purposive interpretation consistently prevails, generous interpretation adds little to constitutional analysis. Would you like any refinements or additions to this note? Next. Use only the subheading numbering you see. Do not add or change subheading numbers. Page. Got it. Here's the revised note with the original subheading numbering preserved. Underscore. 6.3 Tension between generous and purposive interpretation. Minority view, Kantridge A.J. and Mlung case, preference for ordinary meaning. A constitution should be construed generously, but only within the limits of its language. Section 241(8) of the Interim Constitution clearly states that pending cases must be handled as if the Constitution had not been passed. When language is clear, it must be given effect. Majority view, Mlung case, opposition to narrow, legalistic interpretation. Withholding Bill of Rights protections based on when a case commenced is inconsistent with a broad, beneficial interpretation. A generous reading should be adopted if the text reasonably allows it. Challenges of generous interpretation. Conflict with purposive interpretation. The purpose of a provision may be narrow, making a broad interpretation inappropriate. The Constitutional Court acknowledges this tension but has not explicitly resolved it. Risk of strained textual interpretation. Even when the Mlung majority emphasized adherence to language and context, a broad reading may stretch meaning beyond its intended limits. Justifications for generous interpretation. Distinction from statutory interpretation. A supreme constitution cannot be interpreted in the narrow legalistic manner applied to statutes. However, this does not fully explain why a generous approach is necessary. Role of General Limitation Clause. The South African and Canadian constitutions allow courts to first adopt a broad interpretation and then require the state to justify any infringement. This shifts the burden to the government, rather than the individual seeking rights protection. The Constitutional Court's approach. Not fully committed to generous interpretation. The court does not extend rights indefinitely and tends to demarcate them based on purpose. When faced with a conflict between generous and purposive interpretation, the court typically favors purposive interpretation. Implication. If purposive interpretation overrides generosity, then generous interpretation adds little to constitutional analysis. Let me know if you'd like any refinements. Next. Page. Here's the study note based on your text while preserving the original subheading numbering. Underscore. 6.3 Tension between generous and purposive interpretation. Minority view, Kantridge A.J. and Mlung case, preference for ordinary meaning of S. 241(8) of the Interim Constitution. The language is clear, pending cases must be dealt with as if the Constitution had not been passed. Constitutional interpretation has limits. A broad approach cannot override explicit language. Respect for textual clarity is essential. Majority view, Mlung case, opposition to narrow and legalistic interpretation. Bill of Rights protections should not be withheld based on procedural timing. A broad interpretation should be preferred if the text permits it. Challenges of generous interpretation. Tension with purposive interpretation. The purpose of a provision may be narrow, making broad interpretation inappropriate. The court has not explicitly resolved this conflict. Risk of strained textual interpretation. Even when adhering to language and context, a broad reading may overextend meaning. Justifications for generous interpretation. Not merely a distinction from statutory interpretation. Supreme constitutions require a different interpretive approach. However, this alone does not justify a broad reading. Role of a General Limitation Clause. South African and Canadian constitutions allow courts to first adopt a broad interpretation of rights, then require the state to justify any limitation. This shifts the burden away from the applicant. The Constitutional Court's approach. Not fully committed to generous interpretation. Rights are not extended indefinitely to all possible activities. The court tends to demarcate rights based on purpose. Implication. If purposive interpretation prevails, generous interpretation adds little value. Let me know if you need refinements. Next. Page. Here's the study note based on your text while preserving the original subheading numbering. Underscore. D. Context. The meaning of words depends on context. Constitutional provisions must be read in context to determine their purpose. I. Historical context. A. Political history. South Africa's political history is central to constitutional interpretation. The Constitution represents a decisive break from the past. Rejects apartheid, racism, authoritarianism, and repression. Promotes democracy, human rights, accountability, and transparency. Muhammad J. emphasized the need to interpret provisions in light of this break. The Equality Clause in Brink v. Kitchoff No. Apartheid systemic discrimination, for example, land ownership, jobs, education, public services. Legacy of discrimination shapes interpretation of equality rights. B.B. Drafting history. Statements by politicians during negotiations, ipse dixit, are of little value. S.V. McQuanian, quoting Canadian case. Too many actors involved in the drafting process. No single viewpoint is determinative. Constitutional Court's stance. Individual statements are unreliable, regardless of prominence. Background materials from the drafting process, travaux preparatoires. Recognized as relevant for constitutional interpretation. S.V. McQuanian. Technical committee reports provide context for constitutional provisions. Example. Deliberate omission of qualifications on the right to life left the death penalty question to the court. McQuanian criteria. Background materials must be clear, undisputed, and relevant. Officially recognized documents are rarely in dispute. Weight of background evidence. Always informative but rarely decisive. Let me know if you need any refinements. Next. Page 2. Textual context. Courts use other provisions of the Constitution and Bill of Rights to interpret individual rights. Rights must be understood in both their social/historical and textual settings. Systematic interpretation. Constitution must be read as a whole, not as isolated provisions. Courts must harmonize provisions to give effect to all of them. Key case law. S.V. McQuanian. The right to life, equality, and dignity inform the prohibition of cruel, inhuman, or degrading treatment. S. 11(2) of the Interim Constitution. The arbitrariness of the death penalty makes it cruel and infringes on both equality and the right to life. Ferreira v. 11. The right to freedom of the person. S. 11(1) of the Interim Constitution, now S. 12(1), must be interpreted within its context. Found alongside prohibitions of detention without trial, torture, and cruel treatment, indicating its primary purpose is to protect physical liberty. The requirement of necessity for limiting this right, S. 33(1) of the Interim Constitution, suggests it protects a higher order freedom. Hauteng School Education Bill case. Petitioners argued S. 32(c) of the Interim Constitution meant everyone could demand education in schools based on a common culture, language, or religion. Muhammad D.P.'s contextual analysis. S. 32(a) guarantees basic education at public expense. S. 32(b) ensures education in one's language of choice. S. 32(c) must mean something different, the right to establish private educational institutions based on common culture/language/religion. This interpretation avoids redundancy and aligns with South Africa's history of restricting private education during apartheid. Subramani v. Minister of Health, Kwa Zulu-Natal. Court held S. 11, right to life, does not impose a positive duty on the state to provide life-saving treatment. Medical treatment obligations fall under S. 27, which expressly outlines healthcare rights within available resources. Contextual interpretation prevents creating additional state duties beyond what the Constitution provides. Limitations of contextual interpretation. Risk of limiting rights rather than interpreting them. The Bill of Rights follows a two-stage approach. 1. Interpretation. Establish the meaning of a provision. 2. Limitation. Balance rights under S. 36. Context should not be used to limit rights during the interpretation stage. Risk of ignoring relevant rights. Courts must test laws against all potentially relevant rights, not just the most obvious one. Contextual interpretation must not be a shortcut to dismiss rights as irrelevant. Let me know if you need any refinements. Next. Page 6.4, the Interpretation Clause. Section 39, Interpretation of the Bill of Rights. 1. Obligations of courts, tribunals, and forums in interpreting the Bill of Rights. S. 39(1)(a), must promote values of an open and democratic society based on human dignity, equality, and freedom. S. 39(1)(b), must consider international law. S. 39(1)(c), may consider foreign law. 2. S. 39(2), courts must promote the spirit, purport, and objects of the Bill of Rights when interpreting legislation or developing common/customary law. 3. S. 39(3), the Bill of Rights does not override other rights/freedoms recognized by common law, customary law, or legislation if they are consistent with the bill. Underscore. A. Section 39(1), Values, International, and Foreign Law. Interpretation must align with abstract/ideal democratic values rather than South Africa's current social realities. Public international law, both binding and non-binding, Canadian interpretation, S.B. McQuanian, includes international agreements and customary international law. Decisions of international human rights tribunals, for example, UN Human Rights Committee, Inter-American Court, ECHR. Reports of specialized agencies, for example, ILO. Foreign law may be considered but is not mandatory, S.B. McQuanian. Constitutional Court's approach to foreign law. Comparative research is useful for new jurisprudence but must be applied cautiously. Foreign law cannot be transplanted directly due to differences in legal systems and societal contexts. Example, speedy trial rights cannot be interpreted using U.S. case law, Barker test, because most South African accused persons are unrepresented. B. Section 39(2), Indirect Application of the Bill of Rights. Not about constitutional interpretation but about how the Bill of Rights influences other laws. Requires courts to interpret statutes, common law, and customary law in light of the Bill of Rights. Closely linked to S8, the Application Clause, ensuring a permeating effect of constitutional values on all law. C. Section 39(3), Coexistence of Other Rights. Confirms that the Bill of Rights does not negate other rights provided by common law, customary law, or legislation. However, such rights must be consistent with the Bill of Rights. Example applications. The right against self-incrimination, S35(3)(j), applies to criminally accused persons, but others may still rely on common law self-incrimination protections. A person denied hotel accommodation may seek redress under the Promotion of Equality and Prevention of Unfair Discrimination Act 4 of 2000 rather than the Bill of Rights. 6.5. Other provisions of the Constitution. The preamble may assist in interpreting the substantive provisions of the Bill of Rights. Chapter 14, General Provisions, contains additional interpretive rules. S240. If there is inconsistency between different texts of the Constitution, the English text prevails.